I'm Susan Murphy, lead attorney at Advocate Legal. This video is about deficiency. A lot of you ask us about deficiency after foreclosure. What you're really asking about is deficiency judgment after foreclosure. In California, we have something called the one action rule, which affects the beneficiary's right to get a deficiency judgment. So how does this work? First, you need to know the difference between a deficiency and a deficiency judgment. A deficiency is the difference between the principal balance and the sale price at foreclosure. This means that if the bank sold your house for $300,000 and you still owed $500,000, your deficiency at foreclosure sale would be $200,000. A deficiency judgment is the way that the beneficiary can get this money back from you. This requires a court case where the beneficiary goes to court as a plaintiff and mounts an evidentiary suit before a judge or potentially a jury. And if they win, they receive a deficiency judgment. So what is the one action rule? The one action rule means that in California, there can only be one foreclosure action and any damages for the deficiency must be resolved at one time. This can only be done by judicial foreclosure, although both judicial and non-judicial foreclosure are allowed in California. Non-judicial foreclosure is what happens to most of us in California. It's easy for the beneficiaries, it's done by notices, and there's no going to court. However, this will count as the beneficiary's one action, and with a few exceptions, they won't be able to come after you later for a deficiency judgment. Judicial foreclosure requires the beneficiary to sue you in court as a plaintiff with you as a defendant. For the deficiency part of the suit, the beneficiary will have to show that they got the best possible price for your property, that the sale was conducted properly. Beneficiaries will do a judicial foreclosure if they're after a deficiency judgment, since this will be their one opportunity, the one action, where they can seek and receive a deficiency judgment. Many borrowers misunderstand the difference between a deficiency and a deficiency judgment. But the deficiency is simply an amount, a number, and not the same as a judgment. A deficiency judgment is a personal judgment against you and therefore requires due process, which means a hearing, an opportunity to be heard, a chance to put on evidence, and a right to appeal if a judgment is granted against you. If someone comes after you for a deficiency, make sure they show you the judgment. Other states don't have the one action rule like we have in California, meaning that beneficiaries can come after you years later in a second action for a deficiency. The statutory period for this varies by state. For example, in New Hampshire, a beneficiary has 20 years from the foreclosure sale to go to court and sue for a deficiency. The best way to avoid this, if you are in one of these jurisdictions, is to settle with the beneficiary at the time of foreclosure. Remember that if you reside in another state, you will come under their deficiency statutes and may be subject to a deficiency judgment in that state. This will be played out in the next few years as property values rise again, as people recover the personal wealth they lost during their foreclosure, and as beneficiaries seek to come after borrowers for additional money. At Advocate Legal, we'll be here, as usual, standing between the bank and your money.